Welcome, everyone, and thank you for joining us at the Center for Justice and Human Dignity as we gather to kick off our 4-week virtual panel series to discuss the role of the United States Sentencing Commission in decarceration, the First Step Act, and beyond. My name is Caitlin Flood, and I am the Director of Release Reform Initiatives here at the Center for Justice and Human Dignity. And we've shared a little bit more about CJHD through materials on your attendee hub through our CVent conference platform. And there'll be instructions on how you can get those materials and also visit us at cjhd.org if you're interested in learning more. We would like to recognize and thank the Federal Sentencing Reporter, a journal led by Doug Berman and Steve Chanenson, experts in the federal sentencing field, who collaborated with us at CJHD with the goal of facilitating conversations around the United States Sentencing Commission and what could be done to advance sentencing reform through this bipartisan, independent judicial agency that we're anticipating will take up some increased airtime this spring, summer, and fall of 2022, and hopefully beyond. We'd like to start the panel series by kind of setting the stage about this topic, since we know we'll have legal practitioners, researchers, service providers, and community-based organizations who work kind of across federal and state arenas. And certainly while we acknowledge that most of the content in this 4-week panel series will focus on federal sentencing, we hope that the speakers' insights and experiences around what initiatives have worked well in the states will also be able to serve and inform the federal sentencing field and vice versa. So first, a quick note on the potential for change in the coming weeks and months with regards to the Commission's current composition. Since 2018, we know that much attention has been paid to federal sentencing in light of the First Step Act, which reduces certain mandatory minimums, contemplates retroactivity of past legislation under certain enumerated circumstances, and expands sentencing review opportunities more generally. At the same time, we know that the repercussions of COVID-19 moving through crowded correctional facilities has also made stakeholders reconsider who is being held in custody, the health risks that are posed to individuals serving their sentences in these facilities, as well as correctional staff and their families. And more generally, what purpose lengthy sentences serve in 2022. Concurrently, the Commission tasked with promoting proportionality, transparency, and alleviating federal sentencing disparities. That's the U.S. Sentencing Commission. We know that this commission requires a quorum of 4 voting members to act. Yet we also know that this commission has faced persistent vacancies in the last few years. This has precluded, to some extent, the commission from updating sentencing guidelines and has slowed the pace of disseminating research and data and reports around sentencing alternatives, recidivism, and public safety outcomes related to the federal sentencing guidelines and in the federal sentencing arena more generally. So next, we wanted to just share a quick note about why we at CJHD wanted to ask the subject matter experts about the role that the United States Sentencing Commission can play towards advancing decarceration and addressing mass incarceration more generally. Interestingly, when Congress transformed federal sentencing through the Sentencing Reform Act of 1984, it expressly instructed the new U.S. Sentencing Commission to prioritize alternatives to incarceration for many individuals serving federal sentences, and to prioritize prison sentences for only a small subset of federal offenses. We know specifically that Congress noted in different sections of that act the general appropriateness of imposing a sentence other than imprisonment in cases in which the defendant is a first-time offender who has not been convicted of a crime of violence or an otherwise serious offense. But while a third or more of all federal offenses involve first-time offenders, and only a small percentage of federal offenses are crimes of violence resulting in bodily injury, year after year, we see that the vast majority of those convicted of federal offenses are sentenced to some term of prison, some carceral sentence, and often for long periods of time. Starting with today's panel and throughout this series, you will hear from subject matter experts who will discuss the limitations around current alternative to incarceration practices in the federal space, especially when compared to state alternative to incarceration programs. The dearth of federal alternative to incarceration programs has certainly had a profound impact on the federal prison population, which was under 36,000 individuals when the United States Sentencing Commission was first created in 1984. But we know that that federal prison population had then ballooned to nearly 220,000 by 2013. According to the Bureau of Prisons website, as of April 2022, the federal prison population is now at about 155,000 individuals. So certainly, while this number is down from 2013, we should be analyzing this number in the federal prison population in the context of the global pandemic that we've experienced over the last 2 years. And arguably certain untapped opportunities for more expansive releases through home confinement, community supervision opportunities where appropriate, compassionate release, because we know that about 2/3 of individuals currently in federal custody are serving sentences for non-violent offenses, according to the Bureau of Prisons statistics. Significant policy and legislative changes by both Congress and the Commission have contributed to decreases in the federal prison population over the last decade or so. And certainly Congress's passage of the First Step Act in 2018 reveals a continued commitment to minimize excessive incarceration. And the Commission, through its own data collection, its past review and analyses in reports, has often sought to promote greater use of alternatives to incarceration, and has also shown a light on concerning disparities within the federal sentencing system. With new appointments to the Commission forthcoming and a federal prison population that is still quite high, it's a uniquely important time and exciting time to explore how the federal system can now fulfill Congress's original expectation that our sentencing guidelines, policy statements, and on-the-ground practices will reflect the general appropriateness of imposing sentences other than imprisonment for many individuals. So with guidance from former commissioners and chairs, as well as current federal practitioners and researchers, we have this opportunity to reimagine how the Commission might use tools, including sentencing guidelines, policy statements, and data collection, as well as publishing reports to advance decarceration opportunities and address system disparities, and really to galvanize reflections on the current changes in federal legislation and ideas that experts have about how the Commission can potentially expand its role. We at CJHD have worked to gather subject matter experts in the field working on these issues every single day, and who will be sharing diverse views and recommendations. So during this weekly series in May, judges, scholars, and practitioners will share their thoughts and insights on how the Sentencing Commission can be supportive of federal alternative to incarceration programming, different sentencing review mechanisms, including compassionate release, promising practices and initiatives from different state sentencing commissions, and changes to or clarifications of current guidelines that practitioners and other leaders in the field are interested in seeing once commissioners are appointed. Speakers will also reflect on how legislation like the First Step Act have expanded opportunities for decarceration, what further legislation is required to implement certain proposed reform, and then also the steps that the Commission can take separate and apart from congressional action. The goal of the series is really to highlight opportunities for the Sentencing Commission to be reinvigorated, such that federal sentences and sentencing practice reflect current law and data, really with an eye towards achieving fair outcomes. By bringing together experts who are well-versed in federal sentencing and the Commission's authority, the content in this series will hopefully present ideas and guidance that incoming commissioners can reflect on and ultimately act on. We are incredibly grateful for the time, the talent, the humility and humor and wise insights of all of our speakers, and are really excited to hear back from you all who are joining us for today's session and hopefully for our future Tuesday sessions in May to engage in discussions about these issues that we know are urgent, impactful, and timely. Welcome, everybody, and thanks for joining. We are excited to start our panel series this month and kick off this series today with a topic that we hope is centered during future conversations and policy initiatives led by and informed by the United States Sentencing Commission. And the focus of today's panel is on alternatives to incarceration, reducing mass incarceration within federal courts. Our panelists today will discuss the legal basis for alternative to incarceration sentencing, and we may refer to this alternative to incarceration phrase as ATI just for brevity's sake. And the panel will also be looking at opportunities to incorporate restorative justice into all touch points before, during, and after federal case disposition and sentencing. Judges and practitioners representing active ATI programs and who are actively embedding restorative justice principles into their day-to-day work will share with us how to operationalize these programs and practices, really regardless of differences in funding, capacity or bandwidth, and political circumstances across diverse jurisdictions. All factors that we know can sometimes pose challenges to formal or informal alternative to incarceration programming. The panel will highlight current challenges to evaluating federal ATI programs, the additional research needed to expand these types of initiatives, and then the impact of pretrial and pre-disposition release out into the community, and what impact pretrial release has on sentencing outcomes. The panel will also look at how the United States Sentencing Commission might support or enhance these models and the research around them, and provide options to supplement or replace longer terms of incarceration through these ATI programs and restorative justice practices. So today we're honored to have 4 distinguished leaders who have made really inspiring contributions in the field of alternative sentencing and restorative justice practice across various touch points of a criminal case and the sentencing process. So with us today, we have Judge Dolly M.G., the United States District Court Judge for the Central District of California, founder and leader of the Conviction and Sentencing Alternatives Program, also known as the CASA program. Joined with Judge G is Raul Ayala, Deputy Federal Public Defender at the Office of the Federal Public Defender in California, and also a contributor to the CASA program. Judge Leo Sorokin, District Court Judge of the District of Massachusetts, founder of the District of Massachusetts Court Assisted Recovery Effort and RISE program. And then last and certainly not least, Chris Dozier, who serves as a federal representative on the board of National Association of Pretrial Service Agencies, or NAPSA. And Ms. Dozier is also the retired chief of the United States Pretrial Services Agency in the District of New Jersey. So without further ado, let's dive into the content of today's panel discussion. And thank you for being here with us today. We're fortunate to have such creative and collaborative leaders who have dedicated their careers to expanding and diversifying responses to sentencing. So we're very grateful for your time and insights today. Before we jump into the content of our panel discussion, we did want to acknowledge that the terms alternatives to incarceration and restorative justice principles or practices are labels that have been defined and interpreted in many different ways across state and federal systems over time. And we are more than happy to hear all of your descriptions of these programs and sentencing opportunities. But to provide some additional framing, we'll be using these terms in their most expansive and inclusive context. So really any practices that provide opportunities for non-carceral sentencing, or if a custodial time is unavoidable or mandated by federal sentencing guidelines, looking at restorative and rehabilitative principles that can guide judges, practitioners, justice-involved individuals, and communities harmed. And so we're very excited to learn more about the innovations your teams have led and hear your thoughts on how your work might inform and relate to next steps for the United States Sentencing Commission. So we'll jump right in. And we'd love to start by hearing about the CASA program in California with Judge G and Raul Ayala, and then turn to Judge Sorokin, who leads the RISE program in Massachusetts. So we're hoping that you could all share an overview of your programs and how they provide opportunities for individuals to engage in treatment, restorative justice practices and opportunities, and then pretrial supervision that can help individuals avoid or at least reduce exposure to incarceration. So Judge G, if we could start with you.
Thank you, Caitlin, for providing me an opportunity to talk about something that's near and dear to my heart, the Central District of California's Conviction and Sentence Alternatives Program, also known as CASA, as you mentioned. The CASA program is a post-guilty plea pre-sentence diversion program, which we like to refer to as a no-entry program. It is an innovative program that launched in 2012 through a very fruitful collaboration between our court, the United States Attorney's Office, the Federal Public Defender's Office, and the Pretrial Services Agency in our district. So this year, I'm proud to say, marks our 10-year anniversary and nearly 400 participants who have gone through the program thus far. Upon successful completion of the CASA program, successful participants are diverted away from the criminal justice system entirely by dismissal of their charges, or steered away from prison through probationary sentences that have been agreed upon under Rule 11C1C plea agreements. As far as I'm aware, it's the first of its kind in the nation that was not solely a drug court, but allowed a variety of criminal defendants to participate so long as they could benefit from a period of intensive supervision tailored to address the underlying basis for their criminal conduct. So, for example, CASA participants may have substance abuse problems, mental health disorders, specific medical concerns, life skill deficits, or negative familial or peer influences. We use a combination of outside service providers, court resources, and one-on-one and group meetings to address these issues during the course of their 1 year, and sometimes, if necessary, up to 2 years of participation. Currently, our graduation rate is at approximately 82%. Perhaps I can talk a little bit more about the nuts and bolts of how all of this happens. We have 4 district judges in our district who preside over the CASA program. There are 2 judges in our Los Angeles division, and then 1 judge in our Santa Ana division and 1 in our Riverside division. And each of these district judges is part of a team. The CASA team consists of 1 district judge, 1 or 2 magistrate judges, representatives from the U.S. Attorney's Office, representatives from the Public Defender's Office, and the Pretrial Services Agency. All of the team members volunteer their time and receive no additional compensation or relief from their existing workload. So it is a labor of love. CASA participants are designated as Track 1 or Track 2 participants at the time they're accepted into the program. Typically, track 1 participants are those who have minimal criminal histories or whose criminal conduct appears to be an aberration that could be appropriately addressed by a period of supervision. Track 2 participants, on the other hand, tend to have more serious criminal histories or have had a role in their criminal offense that cannot be described as minor. Their criminal conduct typically will be motivated primarily by substance abuse, mental illness, or negative peer influences. Track 2 participants in our program have ranged from criminal history categories 1 through 6. But the CASA team has determined through the vetting process that their criminal behavior can be deterred through intensive supervision accompanied by drug or mental health treatment and other resources that I've mentioned. Certain types of criminal cases generally are precluded from participation in CASA. For example, crimes involving child exploitation, national security, crimes of violence, or more than a minor involvement in large-scale fraud or narcotics distribution will typically preclude a person from participating in the program. We have a vetting process that is comprised of the U.S. Attorney's Office, PD's Office, and Pretrial Services Agency, who participate in meetings to vet the various applicants. The judges typically do not participate in that, but once there is consensus between those who have been in the vetting process, the proposed participant is submitted to the judge, who then approves or disapproves, usually approves the participation of that particular applicant. Following their guilty plea, CASA participants typically meet bi-weekly with the CASA team in the district judge's courtroom. And on the other weeks, when they're not meeting in person in the courtroom, they participate in MRT, moral recognition therapy, which includes a component of restorative justice principles, but not quite as elaborate as that I'm sure Judge Sorokin will address in his remarks. The CASA program places a great deal of emphasis on honesty and integrity. Those concepts are incorporated into the CASA agreement signed by each participant and stressed during the course of the program repeatedly. We also have the participants engage in various homework assignments. In addition to their drug treatment, mental health treatment, and other outside resources that they take advantage of, they're also exposed to a wide range of topics during their sessions with us, including ethical questions, specific discussions relating to employment skills, financial literacy, health, nutrition, stress management, and other issues of common interest. Sometimes we have enthusiastic CASA graduates who return to speak with our participants about their experiences. And we are always open to having people who want to give us free services to talk about issues that we think might be of benefit to our participants. CASA participation, as I mentioned, lasts from 12 to 24 months, depending on the defendant's progress. Graduation is not automatic. Rather, participants have to either hold a job or make some progress toward an educational goal, be substance-free, pay restitution if applicable, and show stability in their lives. Additionally, the CASA teams look for a solid and realistic life plan that convinces us that each participant is ready for graduation and is not likely to reoffend in the future. So these are some of the milestones that we like to take into account in determining whether participants will graduate. I'm very proud of the program, and I'm sure that Raul Ayala will be able to add some more insights about it.
That's great. Thank you so much, Judge. Yes, and Raul, if you wanted to kind of add your perspective as one of the lead defenders in the program and maybe just highlight one or two takeaways on how defenders and other practitioners have participated in the CASA program. Raul, you're just—
Sure.
yeah.
Thank you, Caitlin, and the Center for Justice and Human Dignity for inviting me and for putting me on this panel with these excellent speakers. I'll add a couple of things like you suggested. I think first and foremost, for us as defenders, it really has brought us into a collaborative court team, right? When we didn't have this alternative, it was, as you know, we resort to our typical adversarial roles, right? And in this case, with respect to CASA and our other collaborative court team, our other collaborative court program, we do work together with the court, with the government, with probation, to a certain extent with treatment providers, trying to figure out what is in the best interest of that particular client to address the issues that he or she presents, right? Doesn't mean we always agree on what has to be done, but we approach it together, right? So I think that that's a novel thing that I welcome, and we've developed that over 10 years. I work in all 4 courts, so I can tell you hands down that our teams approach it with open mind, with respect, understanding, and open communications about what needs to be done. And of course, the what needs to be done always calls upon behavioral health principles, right? And that's hard for criminal law practitioners or people in the court system, right? We're not trained that way, right? And to be able to fully understand those and apply those in the way they're intended with fidelity to those modalities or to those principles is a tall ask, a big ask for us to do, right? Judges got a number of cases. We have cases. The government, everybody has a lot of work. So to spend time and get up to speed is a challenge. So I think for any program, as much time as you can invest on understanding the basic behavioral health principles, what's involved, what criminal law professionals in the court system can do to add a value to those treatment modalities is a plus. So those are both challenges and real benefits when we get to that point.
That's great. Thank you so much, Raul.
Of course.
Judge Sorokin, we'll turn to you.
Thank you. So in some respects, our program is much like CASA. And we created it after CASA. We looked at CASA and certain other programs as models. And the way it's similar is that our program is a front-end program like CASA. It's a program for people who are on pretrial release. It's a program for people who have serious substance abuse problems that are substantially contributed to their offense that brought them to the federal court. It's a program like CASA that's not limited to people with substance abuse problems. We also take people who have serious deficiencies, for example, in education, family structure, or display significant criminal thinking. So those parts of the program are similar to the construction of CASA. There's also some significant differences. The first is that in our program, in order to participate in the program, you must plead guilty, and you do it relatively early. The second difference between our program and CASA is in our program, we defer sentencing for a year, 12 months, but not for 24 months. And the third difference, significant difference, is that we don't promise or guarantee any particular outcome at the sentencing. So there isn't a per se graduation, and there isn't a promise or that if you graduate, you will get a dismissal or you'll get a specific reduction. Rather, what we promise people is that whatever you do and whatever facts that develop during that year, those will be fairly considered by the judge in the context of all the relevant facts at sentencing. People come into the program in what I think is a somewhat similar process, in the sense that we also have the similar exclusions, the same kinds of categories of people that CASA excludes, pretty much are the kind of people we exclude. People come in through a committee, reviews them. The committee is composed of probation, some judges, a representative of the defenders, a representative of the U.S. Attorney's Office, and while in the end, and the committee makes a non-binding recommendation to the judge whose case it is as to whether to accept the person or not. The committee, in the end, the judges and probation can make a unilateral decision about the recommendation, but in the years that we've been running the program, that's never occurred. It's always been a consensus, or at least as to the government. And that is, we've never taken anyone over the government's objection. The judge, though it's a non-binding recommendation, has typically always accepted the recommendation. And we similarly provide or make available to people the kinds of arrays of appropriate services and treatment options that Judge Gee has described that they do in CASA. And we also, which I think they have in CASA, we have a monthly status hearing before a magistrate judge. The one other significant difference that's a central piece of our program is that we have everybody who does RISE, which stands for Repair, Invest, Succeed, and Emerge. Everyone who does RISE must do the restorative justice program. You don't have to do RISE, it's completely voluntary, but if you want to do RISE, you must do the restorative justice program. And the reason and purpose behind that is the purpose of the restorative justice is to help defendants appreciate that the crime that they committed caused harm. And it's also to help them begin to think about how they might make it as right as possible. And it's also, the restorative justice program is a place to give victims, those victims who wish it, and only those who truly voluntarily wish it, but for those who do, an opportunity to participate in what many of them find a healing process. So the restorative justice program itself has 4 components. The first is about 1 hour meeting between one of our facilitators and the defendant who's going to participate. Our facilitators are a mom whose son was murdered in an armed home invasion, who participated before we had our program with some of the perpetrators of that offense. She's one of our facilitators. And originally, the other facilitator was one of our probation officers. And we've now expanded to include several AUSAs and one defense attorney who also work as a co-facilitator. And the purpose of that 1 hour meeting is half to educate the participant, defendant, as to what is restorative justice and what kind of questions will be asked and what they might expect in the program. And the other purpose is some assessment of the person to get a sense of who might be good matches to participate with this defendant in part 2. Part 2 is the meat, so to speak, of the program, of the restorative justice program. It's a 2-day, 16-hour circle workshop. And in the circle would be led by the 2 facilitators. The 3 to 10 defendants would be in the circle. Some number of what we call surrogate victims, people who've been victims of crimes, but not victims of the crimes committed by these defendants. That's typically because those defendants' crimes under federal law are deemed victimless. For example, drug distribution or felon in possession of a firearm, for example. So we'll have people who've been, say, a mom whose son died of a drug overdose might participate as a surrogate victim in that. And that's sort of the healing opportunity for victims who wish to participate. There'll also be some community type members in the circle. We originally did it for 2 days in person. In COVID, we've converted it to 4 4-hour Zoom sessions, and that's worked pretty well. Those 2 parts are required. Parts 3 and 4 are voluntary. Part 3 is readings and reflections. Sometimes they're individual readings and reflections selected by probation for the person about sort of restorative justice principles, which chiefly are relating to questions like what kind of harm was caused, who was harmed, how were they harmed, who's responsible for that harm, what can be done to repair the harm, who might be responsible to repair the harm. Sometimes the readings are done more as a reading group that's led by one of the facilitators. And then part 4 is an individual repair project designed or developed by the defendant participant in conjunction with the assistance of one of the facilitators. That's most typically been a one-on-one apology to somebody who's been harmed. What we have found is that, which we think is unusual, in my experience, most defendants in federal court don't volunteer to do more with US probation. That whatever's required, they might do, but they don't wish to volunteer for extra things. And what we found is 80 to 90% of the people who participate in parts 1 and 2, which are required, choose to volunteer to participate in parts 3 and 4. And what we found is people really like it, and they like the experience. And what we found that's really positive is it's really seems to be leading to a couple things. A change in people's relationship to crime and to the system, because they're many, for example, we've had a number of drug addict drug dealers who said before they went through the circle, even though they might have done drug treatment, they really didn't think they did anything wrong. They didn't think there was anything wrong with selling drugs. They did drugs. What's the problem? That's what one of them said. And it wasn't until they sat in the circle with people who had been harmed in some way by the illegal drug distribution trade that they began to realize what was sort of wrong with what they were doing. And it's that kind of emotional learning that's one of the things that we think is very powerful about it. And the other is it gives victims and people who've been harmed by crime an opportunity to engage and be empowered in a way that's helpful to them. So one mom said to me that she went into the circle with some trepidation. Her son had died of a drug overdose. She knew she was going to sit in a circle with some men who had been convicted of selling drugs. And she thought, why am I going to sit in a circle with people who are monsters? Because only monsters would do this. And she said that when she came out of the circle, she had several changes in herself. One was she learned something from this process that she could take to her daughter, who was at home and was in a difficult place because her older brother was dead. And she learned some things here, got some answers and some insights that she didn't get and wouldn't get from the regular process that she was able to take home to help her daughter. And I thought that was a really wonderful thing that we were able to provide and really important. And the other was she had a different insight into these men. And to some of those men, she remains in a relationship with, and remains friends with them. And those relationships and connections are helpful and productive in changing people's course. And so that's, in a nutshell, the summary of the program. And the last thing I just say is we've now made the restorative justice program available to people who aren't in RISE.
Caitlin, if there's a moment to spare, I just wanted to clarify something that may have arisen from anything that I might have said, which is that our CASA program also is a post-conviction program. So those who participate have actually been convicted of their crimes. And once they complete the program successfully, those who are in track 1, they withdraw their guilty plea and the government dismisses the charges against them and they do not have the felony conviction. Those who have been assigned to track 2 would be sentenced to a probationary sentence. And if they don't successfully complete the CASA program, then they are sentenced pursuant to the regular course as though they had not participated in the CASA program.
So I should just clarify with this, that's super helpful, Judge Key. And I should say in our program, the program document memorandum of understanding provides for the possibility that the government would dismiss or dismiss the charges in a case the government thought appropriate, or reduce the charges, but that hasn't actually ever happened. And it's solely under our program in the discretion of the government. The second thing I should say for all the other people, if they don't quote succeed, so to speak, yes, it's sentencing in the ordinary course. And though we don't promise people anything, most of the people who go through the program have received time served probationary type sentences. More recently, we've seen a willingness generally to accept people into the program who are facing bigger sentences than we had previously been accepted. And so some of those people are sometimes, despite success, receiving lower sentences than they otherwise would have, but coming to sentencing and still receiving some further incarceration.
Thank you both for clarifying that. And I think what both of your comments and then follow-ups really delineate is just how varied the options are, both jurisdiction specific, kind of what's allowed in different courts, but then also culturally what different practitioners are comfortable with, and then also how these programs have developed over time in terms of the breadth of eligibility and when program participation is going to take place, whether it's pre or post disposition. And then, another theme I kind of heard coming out of this is really expanding the opportunity for some of these resource connections, restorative justice principles, in a broader way, and even if an individual can't be a participant of the more formal CASA or RISE program. So that's great to hear. And I think actually is a great segue to our next speaker, Chris Dozier, who's going to help us kind of pick apart a little bit why it might be difficult or a challenge to evaluate and formulate any type of formal randomized controlled trial, because these alternative to incarceration programs are so distinct and unique based on jurisdictional practices and culture and changes and differences in the law. So Chris, thank you for your patience, and we're excited to bring you into the conversation. So from your experience as a former chief of U.S. pretrial office, you've had a lot of important and different perspectives around what information can be gleaned from assessments for these alternative to incarceration programs. And we know that you've done work around how to determine not only who is appropriate for these programs based on risk, need, responsivity principles, but also how we determine if these interventions are in fact working, or how to even define success in a program. So we would love for you to speak a little bit about your work trying to advance different evaluations of these alternative to incarceration programs, and what the challenges are around engaging in this research, but what the benefits might be of focusing more on not just the qualitative outcomes, but quantitative as well.
The challenges are pretty significant in terms of evaluating these programs and doing some research. Over the last decade, there's been a proliferation of these programs all over our federal pretrial system, and they look very different, as you said, different operating principles, different populations. There just hasn't been any standardized policy or direction. The Judicial Conference has taken no formal position on this, and they've just emerged independent of Judicial Conference policy or the Sentencing Commission being engaged. So in 2017, the Sentencing Commission looked at these programs and issued a report, and essentially what they said was that we needed to study them more, and particularly the area of recidivism. So our federal probation and pretrial strategic plan in 2017 identified goals of both studying them and identifying alternatives to incarceration, particularly in low risk and nonviolent cases. So that is what we set out to do. And in 2018-19 timeframe, 7 districts came together, and we collaborated with John Jay University, Dr. Kevin Wolf, and we hired a research coordinator, Laura Baber, who was an analyst, excuse me, with the Administrative Office of the U.S. Courts. And we looked at what participating in an ATI program, what the impact of that would be. Excuse me. And what we found was when we compared ATI participants to non-ATI participants, matched defendants of the same characteristics, that those who participated in an ATI program did significantly better in terms of pretrial outcomes, such as employment and drug use and rearrest, as well as the outcomes of their case. In fact, 50% of those cases were dismissed versus 0 in our non-ATI population, and significantly less incarceration, 26% versus 77%. And of those who did receive incarceration, it was much less, 10 times more for those who were non-participants. So we published that in 2019, and we set about to do phase 2, which was to replicate it with, we had 13 districts involved. The CASA program was involved in the initial research, and both CASA and RISE were involved in our second phase. And we replicated those outcomes. The research showed the same very positive outcomes for participants over non-participants. And we also looked at the issue of equity and fairness. And what we found was, in terms of program success, there was no distinction based on gender or race or offense charged. We found slight differences based on age, with younger defendants not faring as well as older defendants. And in terms of risk level, as risk went up, the success went down, but it was not significant. There was, as you've heard from our panel, the graduation rates have been excellent. Success rates have been excellent. So what remains is the recidivism question, and that has been a real challenge to do. You know, we had to set up a whole methodology for the data, and it was a lot of resources on the part of those participants to enter data so that the data was valid. And we also had districts that were able to have some extra money to be able to hire our researchers and our research coordinator, and that's not true in many areas. So that was a big challenge. We had to get the approval of the FBI in order to run criminal history information, and that took some time and work. So we're in the process of that evaluation now, and we hope to publish those findings soon. The second part I would like to respond to is about, I don't think that we can talk about how to reduce mass incarceration without talking about the impact of mass detention on mass incarceration. There was a research recently published by 2 officers in New Jersey, Dr. Joe DeGrossa and Chief John Mueller, that looked at the impact of the release detention decision on sentencing, and particularly on variances. And what they found was those who were detained throughout the course of their case were 49% less likely to receive a downward variance. And of those who did receive a downward variance, they were 26% smaller. So it just lends itself to this conversation that we need to be having more about the front end impact on sentencing. Judge James Carr from the Northern District of Ohio wrote an article entitled "Why Pretrial Release Really Matters." And in it, Judge Carr talks about that hinge moment, that most important moment of the in-out decision of bail that has such significant impacts, second only to the sentencing decision, for both short and long-term impacts. The fact of the matter is that mass detention begets mass incarceration. And the research has been very clear in this regard, and there's plenty of it, that defendants who are detained throughout the course of their case, they're more likely to plead guilty. They receive more jail sentences. They receive longer jail sentences. They fail at a greater rate under post-conviction supervision. And even when they are released and revoked, their sentences are still better than those who are never released, because they have that opportunity to put their best foot forward, to participate in programming, to work, to support their children. So I think it's very important that our conversation, alternatives to detention go hand in hand with alternatives to incarceration. So that front end conversation has a significant impact on sentencing and beyond.
I think the takeaway there is there's a lot of good work that's out there on the ground, maybe a little bit difficult to evaluate because of all of the differences across programs. But I think your points about mass detention and the relationship between mass detention and then mass incarceration are really strong points in that looking at detention on the front end obviously has strong impacts on what's happening in the middle and on the back end, and who's being considered for these programs and when, both their eligibility, but also kind of longer term success rates in these programs. So what we would like to do next is hear from all of our speakers about what recommendations you all might have for the United States Sentencing Commission related to amendments to the sentencing guidelines, policy statements providing additional guidance to practitioners, or around data collection, kind of building on or enhancing the Commission's initial work in early reports. And so we would love to hear more about what you think the United States Sentencing Commission can do to be more supportive of all of your work, and providing a little bit more clarity, guidance, feedback on both more formal alternative to incarceration programs, but then also incorporating or embedding restorative justice practices within federal sentencing more broadly. And Judge Sorokin, maybe we'll start with you. I saw that you wanted to make a quick comment on pretrial detention, so we'll turn to you first, and then we'll go to you, Raul.
First, with respect to pretrial detention, I wanted to make two observations. Sometimes people think of detention as binary. Either the defendant is detained or released. And I think that's not the proper way to think about the statute in the way it can be applied. I think that the purpose of the statute is, in one part, is to protect the public from what is perceived to be the ongoing criminal behavior of the defendant that led to the arrest. And so there are times when conditions or treatment that could either conditions could be put in place 1 week, 1 month after the defendant's arrest that might not have been available at the beginning, that can lead to the defendant's release and meeting the statutory objective. So it's a bit more of a dimmer switch than a binary. And the second is, I just give an example of one case we had where defendant was detained 3 times, once by me as the district judge and twice by the magistrate judge, pre and post COVID, and I believe properly so. The defendant then participated in sort of a bit of his own restorative justice program by engaging in readings and reflections, both on his own in jail and over the phone with his girlfriend, and put himself in the position then that he came back. And as a result of that, he was able to get a place to live and from his girlfriend's family and a very small bond. And those things changed his release package. And as a result of that, that led to his release. So also it's sort of the dimmer switch. I think participating in things in prison or in jail can make a difference, and those are important. With respect to how to incorporate restorative justice principles in our sentencing practices, I think there are many ways to do it. And I have some related specifically to the guidelines and some otherwise, and I'll just run through them pretty quickly. With respect to generally, without regard to the guidelines, I bring up the base at every conviction, plea or trial, the basic questions that restorative justice asks. Who's been harmed? Have they been harmed? What can be done to make it as right as possible? Who might be able to do that? And the question of harm, I try to give people a little education on, because some people aren't familiar with these concepts or questions. There's certainly the heartland of harm, which flows from the crime that's obvious, say in the drug distribution case, the people who are receiving the drugs and abusing and using it or dying from it. And those are obvious people harmed, but there are other people. So for example, the defendant might be facing prison, might be in detention, and his or her family is harmed. That imposes tremendous consequences and burdens on the family, and they've been harmed by the defendant's crime that brought them there. And so it's not just as the heartland, there's more to it. And so I bring that up so that people can think about those questions and bring them to the fore at their sentencing proceeding. That's one thing you can do. I think a second thing you can do that I've done is with victims in cases where there's actual identifiable victims. You can meet with the victims in a separate on the record status conference to explain the process of the case if it's going to trial and how it all works and what their role is. And I've done that, and I've found that the victims who receive that explanation, they're very appreciative of it. It means the world to them, and it's really not very difficult for us as the judge to do that. And I've never drawn an objection from defense counsel or the government to do it. A third thing you can do is you can educate, I think, victims as to what kinds of things they can ask for. They all know and are well educated that they can ask for prison, and a lot of prison if that's appropriate or that's what they wish. But there are other things that they can ask for. They can ask for services. They can ask for certain kinds of conditions that aren't the traditional kinds of things we think of. They could ask, for example, an opportunity to participate in a process where they might get answers to questions they have. Many victims have questions, and our typical process never gives them the opportunity to ask or the answers. So those are some ideas for the system. As for the guidelines, the Sentencing Commission itself, I have these couple suggestions. One, I proposed years ago at a time when I was testifying at the Sentencing Commission. I think, Judge Key, I can't remember now I think you were there too. And I proposed that they amend the cooperation guideline to expand the authority of federal prosecutors to promote saving lives. And I did that by saying prosecutors should be authorized to ask for a downward departure if a defendant provided substantial assistance in helping drug addicts, particularly drug addicts, this would be best at, to whom he distributed drugs, but drug addicts into getting into treatment and becoming sober. I think that would save lives. It would help the defendant move to sort of the other side of the blue line, much like the theory behind the regular cooperation. I think the moral justification for giving someone a reduced sentence for that is at least equal to cooperation. And it would be up to the prosecutors. So there's no risk of judges or defense counsel taking advantage of that improperly. So that is one thing they could do. A second is a recognition in the guidelines of underlying efforts to repair the harm. There could be a recognition that if the victim and the defendant participated in some sort of process that led to some accountability, that could be considered in terms of the guidelines. And the last point I'll just make is that the sentencing guidelines themselves say that drug addiction often leads to recidivism. And for that reason, that's why departures, I think, for drug addiction aren't permitted. And well, but then it begs the obvious question to me, since there's all this scientific evidence from the National Institutes of Health that drug treatment works. And in fact, it works as well as treatment for heart disease and other chronic diseases, that there should be a recognition of the guidelines that if people participate in treatment and do so successfully, they're not similarly situated to an otherwise identical person who didn't participate in that drug treatment, but had the drug addiction. And that should be considered. And so there are a variety, that's not exhaustive, but I'll stop there. Those are a variety of ways the guidelines could consider restorative justice principles.
Raul, maybe we'll turn to you next for any recommendations that you might have.
I don't know that we have enough time, Caitlin. It's a long list, but let me give it a shot to give it what I think are the most essential. You know, I'll first piggyback on what Chief Dozier and Judge Sorokin said about detention. Part of what I think we need to incorporate more in our system is to use the use of social workers or clinicians in our work, right? We've been fortunate in our office to establish a social support unit. We've got 3 or 4 clinicians, MSW interns, and that helps a lot in doing exactly what Judge Sorokin and Chief Dozier were indicating, getting those resources together to, you know, to present to the court, to get people released, and not just released so they can run amok, but released to the services and or pro-social activities that we all want to see, right? So I think that's important. I think we've seen some offices in the federal system do that. Eastern District of New York, others have spent a lot of time in developing that social work component. So that's one thing generically. But with respect to the Sentencing Commission, I think if we're going to be serious about addressing the problems of mental health, substance abuse, and those factors like you risk the R and R factors that contribute to offenses, and to reduce recidivism, we have to engage in evidence-based practices as best we can within the confines of a court system, of a criminal court system, right? So I think we need strong, specific policy and legal authority to do these, right? Because we're doing them on a ad hoc basis across the country. Chief Dozier just said, we don't have a standard, right? Everybody kind of develops their own. Hey, I'll take it over nothing, right? And I'll take it over what's been done in the past, right? And by and large, it saves lives, it saves money, and it gives people hope, and it gives all the stakeholders, a ray of hope to be able to help people address those underlying issues so they don't keep coming back, right? So that's great. But we need a specific legal authority, I think, if we're going to do widespread, and with that legal authority, through the Sentencing Commission, through Congress by statutes, Department of Justice, the Judicial Council, those kind of that kind of emphasis or that kind of support will then lead to increased personnel, increased training, increased resources to really try to make a dent in this issue, because it's obviously, we all know it's a huge issue in our country, right? Mental health, substance use, co-occurring, other factors that contribute to criminal offenses. So I think that there are plenty of examples in the state systems that would show what can a criminal justice system do. Well, you can do the X, Y, and Z. You can make it, give the court specific authority to do this, right? You can modify to a certain extent the charging decisions of the U.S. Attorney's Office. Now, as we've heard here more than once, these programs ultimately, at its core, in terms of who gets in, is a prosecutorial discretionary program, right? Again, I'll take it, right? But it isn't complete, if you ask me, right? They shouldn't be the sole gatekeepers, right? They shouldn't be the ones that say, well, we don't think so, and an Article 3 judge can't do anything about it, right? So I think that needs a lot of discussion. I think we need leadership from the Department of Justice. As you know, Attorney General Holder at that time did the Smart on Crime, and certain districts like ours followed suit. But again, it's like, well, we'd like for you to do it, but we're not going to force you, and we're not going to give you a whole lot of resources to do it, right? So that, I think, needs to change. And of course, getting statutes to change in Congress these days is difficult, but we have to engage in a discussion. What is our philosophy on punishment? We're going to bang somebody forever and ever and ever, or are we going to try to do something different? And I know that's a broader discussion than we have today, but it'd be nice if we had a sentencing commission that had a quorum, right? Be nice if we had, open discussions. A lot of these issues, as Judge Sorokin knows and Judge G knows, have already been presented to the sentencing commission. They're on record 5-6 years ago. This, and this, right? And so I think now it's a time to try to effectuate that policy change. And so I'm keeping my fingers crossed and lighting the candle to the Virgin Mary.
Thank you, Raul. And I wanted to also thank you for the shout out to the state sentencing commissions. And you're kind of predicting what our panel will be next week. We have 3 fantastic leaders of 3 different state sentencing commissions. And I do think it's important that while the federal sentencing commission and state sentencing commissions are kind of differently situated and have different impacts, that the two can really learn from each other, because you're right. I think a lot of the innovative things that we are seeing have either taken place at the state level first, or maybe there's a little bit more flexibility. But I think that kind of cross learning between federal and state systems is really important. So thank you for all of that feedback. We'll turn to Judge G next.
65 to 70 per year. We have 4 CASA judges, as I mentioned, and so each CASA team has, in the Los Angeles district, 20 per group, and then in the other districts, they have approximately 10, 12 per group. And that number might have decreased during the pandemic because we weren't vetting as many people. But by and large, that's approximately the number. And as I mentioned, we've graduated nearly 400 people in the past 10 years. I would like to see the program grow. Unfortunately, that is a subject that we have had discussions with our pretrial services probation office about, and that really depends upon the budgetary limitations of that agency, because most of the resources that we have that go to providing services for CASA participants come through our pretrial services office. And so it's very much contingent on what their budgetary restraints are. But we hope to be able to expand in the future.
Yeah, that sounds great. And Raul, I just wanted to leave some space for you if you wanted to address anything around participant numbers or anything else related to the CASA program.
No, I think the court is correct, and the court has inquired about the possibility of a third CASA court, for example, in Los Angeles. And yes, it's dependent on what the U.S. Probation and Pretrial Services Office can afford, albeit we are going more and more to Medi-Cal or public funded for treatment. Still, you need personnel, you need supervision, those kind of things. So, of course, we're all for additional numbers. The U.S. Attorney's Office prosecutes at least 1,000 people a year. There's at least 1,000 new cases. So you can see that we have a very small percentage of people on our program. And of course, we'd like to see that grow.
That sounds great. Thank you. And then, Chris, I wanted to turn it over to you for any kind of final thoughts or reactions to what our initial recorded content was. But before I turn it over to you, I just want to say a really huge thanks to our panelists, not only for joining us today, but as you can tell from this really fantastic content. They got together for minimally 1 hour, but definitely more during prep. So really, we're so grateful for your insights. And just in case either Judge G has to run to court or you have to run to court, Raul, I wanted to say a really big thank you to you all. But then, Chris, I'm turning it over to you for any final thoughts.
Yes, thank you. I do have some final thoughts about what we could do to progress this work. Firstly, the Sentencing Commission, I would like to see take a bigger role in helping to, not just as a clearinghouse, but to educate, train the research. We talked about, we developed this model to do this research that we did with John Jay. So, that prototype has been done. The front work has been done. We need to get all the districts who have these programs engaged so that we can do more research and understand this. The funding issue, the Judicial Conference has provided for a small bit of funding in our last workload formula for the work that's being done here, but it's not sufficient. So we really need the support when it comes to the funding. And my last point is I really think that the Sentencing Commission can get engaged in how the pre-sentence report is being utilized. In certain districts, there's some really great work being done, particularly the pretrial adjustment section and the pretrial rehabilitation section. We saw with our ATI cases how we addressed sentencing very differently. The judges were aware of all the work that had been done with these cases. They were engaged. We would talk about how, risk and trauma and ACEs, adverse childhood experiences, and how the person had put in a lot of work, workforce development, education, training, employment, just a lot of things that were being done on the front end that impacted on sentencing. And I don't think that type of work is being done, certainly with non-ATI cases throughout our country and our system as a whole. So we really need to be doing a better dive into that. And finally, just the last comment to reiterate, I talked about the fairness issue in our research and the success rates across the board, but the selection, and Raul spoke of this, is so dependent on DOJ policy. So we really need to be engaging the DOJ in terms of allowing a broader range of cases to come into these programs because, we know from the research that we should be addressing the highest risk cases for the biggest bang for our buck.
That's fantastic, Chris. Yeah, and thank you for bringing up that point and kind of a transition from that to let you know that we're taking your advice and hearing you loud and clear. We're excited, CJHD is excited to be working to kind of continue some of the work around engaging directly with judges who have either started up federal alternative to incarceration programs, restorative justice programs, so like Judge G, Judge Sorokin, and then also the practitioners who are really keeping these programs sustainable and expanding the programs, the eligibility and the accessibility, the kind of equal accessibility or more equitable accessibility. So CJHD is excited to be partnering with a few different researchers who are going to be helping us to interview judges across the country with differing levels of experience and insights on federal ATI programs. And so we're happy to kind of keep all of our attendees and all of our great speakers in the loop. And just so that everyone who is still with us knows that the recorded panel will be sent out at the end of today's session, along with several resources that have been referred to during this panel session. They will be available also on your attendee hub. And so you're more than welcome to log into the attendee hub at your own convenience, look at those resources, and then we'll be sending a follow-up email so that you can all register if you haven't already for our next 3 sessions every Tuesday at 12 p.m. Eastern Standard Time. And thank you so much for being with us today. So with that, we hope everyone has a very safe week, a healthy and happy week, and we'll see you next Tuesday.